Maneva na sema PENDREAM TV. PENDREAM TV de osia dem yopo.
Bernard.
Well, good morning to co-panelists and to yourself. I've already said that you are a smart lady because I prompted that I was going to take on the issue of the mistitling. You decided to do it faster than I would have done. I will permit it to go for today.
Thank you.
And
it won't happen again.
These things are corrected. In many instances, they can actually cause problems, not within the studio, but outside of the studios. It gives certain difficulties to the person that is involved. Having said that, well, this is a mad fish that has come out of the water to tell us that the crocodile that we feared so much is actually a weak crocodile, a sick. So who are we to say that the mad fish is wrong? Justice Atuguba is not a stranger when it comes to legal work in this country. He has played significant role from the bar to the bench, and at some instances, he had even acted as Chief Justice. And so, as far as the judiciary is concerned, he constitutes one of the colossus of justice delivery in our country. And therefore, many law students and even judges take his judgment as the ones they have to learn from. There are instances that he has been the sole person to dissent on matters before the court. And so, to have the courage to dissent on matters before the court, and sometimes in his dissent, he has suffered for daring to speak away from what the others will do. For me, as Rollins said somewhere, you remember, that Justice Atuguba should be celebrated and that he has not been celebrated. He has shown what judges ought to do. The courage to stand and speak irrespective of who is involved. To make his rulings on the basis of law and fact, not on the basis of who appointed him or not. And in some instances, as he himself pointed out, he virtually was suspended from the courts for 6 months because he dissented on matters that involved the state. He was not empaneled, but he kept his work, and he knew that the day will come he will speak. And we should be grateful that he is speaking. These pronouncements not coming from ordinary citizens, but coming from somebody from the bar to the bench and to the apex serving as acting Chief Justice, will inform the judiciary that when we tell them that they should relook at the way justice is delivered in this country, and they come heavily on us, in some instances they are charging us for contempt for daring the court in their misrulings. Then their own are telling them that some of your rulings, please go and visit it, because as we are beginning to find that the judiciary, after all, is corrupt, that their judgments are laced with partisan eyes, you know that people's confidence in the judiciary will wane. And when that happens, democracy will break into pieces. But see, when the executives and then the legislature are even at war, they have to run to the courts for amity. Now, at the court, you cannot be assured that the right things will be done. So where will they run to?
Yeah.
Where will they run to? Because see, in recent times, you know the decisions between the speakership. That the law is clear that when you are a speaker, you don't participate in the voting. But the Supreme Court, when it came to voting in Parliament, particularly with the rejection of the 2022 budget, what did we see? They said that you can be a speaker and still vote. So you are sitting, and it's a case like a referee. I decide that I'm a referee today, and all of a sudden I go and change my jersey. They are going to kick penalties, and I come and kick the penalty and go and sit back and take my whistle and say, I'm a referee again. So I can actually award penalties and go and kick them.
But Bernard, are we suggesting that cases are not being won at all? Is that what we are saying?
No, but you see, there are cases and there are some cases.
Cases are cases.
No, it's not every case.
Once it can take you to prison, it can take you. I mean,
no. You know what the justices have done? Let me give you an instance.
Tell me.
We say that birth certificate is not a proof of citizenship. Right? Just tell me, as a law student, that birth certificate cannot constitute a proof of citizenship. But a Ghana card can constitute a proof of citizenship. Yet the Ghana card is not obtainable without a birth certificate. So the primary document to obtaining the Ghana card is your birth certificate. And so today, we are telling people by that ruling that our citizenship is defined by Ghana card. And in instances when I don't have a Ghana card, I'm not a Ghanaian. And so there are parents who have to become citizens because their wards have Ghana cards and they have to now go and guarantee for the parents. And yet the Constitution is explicit that any person, I think Article 6.2 or something, it says that any person whose parent or grandparent is or was a Ghanaian is a Ghanaian. Can you underline the is or was a Ghanaian? And so when my citizenship is as a result of being my parentage, you come and tell me that whether your parents are Ghanaians or they were born in Ghana, they have everything to be Ghanaian, you must obtain a Ghana card. That is part of the ruling of the Supreme Court. And you know that it came at a critical time when we were rejecting the new voters register. And when we spoke, we were being cited for contempt. Remember, I spoke and the CJ, the chief, the Attorney General went to court to go and cite me for contempt. And that the court should haul me before it. I am telling you that these things, these kind of rulings, are seen as partisan. Because we're having an issue with the Electoral Commission. The governing party did not have an issue. And the courts go to rule this way. And so in effect, the birth and death registry, in fact, maybe the death registry part should remain, but the birth certificate, birth registry should not be of any consequence. That is what it means. We have to live by it. Yeah, well, you are still young. So, it's evident that that thing may not take you to court, but that thing has ramifications on determining whether I am a Ghanaian or not. And so these things have come up. Justices can be punished. They can be transferred in the case of the Domahine for speaking loud and being courageous. So transferred from Accra to the Volta region. That is your punishment. I know that it was Justice Willie Wise, who one time was embroiled in some corruption issues, that they transferred him from Accra to Sunyani. And I even came out to attack the process. That the man is in Accra and you say he's corrupt. Where you have the Chief Justice and everybody to put an eye on him, you are transferring him to Sunyani. To go and do what? You should take punitive action. Transfers in this manner may not help the situation. And so, for me, it is good that the justices or ex-justices are speaking. And Atuguba is speaking after the former Chief Justice, Gloria Akufu, had even participated in telling government, Sophia Akufu, that pensioner bondholders are citizens and they don't deserve the haircut. So if our justices out of court can now come out and say that, look, they were gagged, now they are ungagged, they can speak, then it tells the kind of democracy we are running.
Yes, I mean, it is you. Good morning to your viewers as well. You have to understand the fact that Justice Atuguba has served on the Supreme Court for I think, over 20 years.
Yes.
And so he speaks from a point of view of experience, both as a practitioner and also as a former judge. And I think we must be fair to look at what he was speaking to, the topic he was speaking to. He was speaking at a public lecture, and the topic was in respect of the role of the judiciary as a defense or a bulwark to defend our democracy, and what was the role of the judiciary. And so he gave his personal experience as a former judge and also some of his experiences as a lawyer when he was practicing. And he looked at the independence of the judiciary both in theory and in practice. And we must open the space as a country for such conversations if we want to be able to improve the judiciary as an institution. Because you know one thing, all of us, when you have a problem, be it with your neighbor, with the government, with anyone, it is the judiciary that you go to for resolution.
Right.
And so we have a stake in ensuring that at all material times our judiciary is improving. And so I want to look more at the lecture that he gave from what he gave as contributions, positive contributions towards attaining a more independent judiciary. And I think he dwelt on a number of very important topics. He spoke, if you look at his lecture in the concluding part, he spoke first about the fact that the judiciary must be both independent in theory and in practice. And what is the theoretical independence? If you go to the Constitution, our judiciary is supposed to be independent. It's not supposed to be subservient to any other institution. It's supposed to have insulation from all manner of interferences from the executive and all other branches. But does our judiciary, is it financially independent, for example? That is one of the critical areas where it is almost subjugate to or subject to the executive. Their budget continuously is slashed. It is one of the things that the current Chief Justice keeps complaining about, that we need to make the judiciary financially independent. And one of the things they have been fighting for is for them to be able to use their internally generated funds to be able to improve the judiciary. I'm hoping that we get to a point where the judiciary can use 100% of its internally generated funds to support the judiciary, because the judiciary needs those funds in order to be able to improve the service conditions. It's one of the things he spoke about, having an attractive financial package for judges so that the judiciary is independent. We shouldn't have a situation where the judiciary, at their annual meetings, they are always complaining about their allowances, their transport allowances, their clothing allowances. All these things are always delayed. They literally have to go and negotiate at the executive. It is not right. So if you have a situation where we have to have our Honorable Chief Justice and the Judicial Secretary and other persons having to go to the executive to go and negotiate and in fact, if the judicial service does not go on strike sometimes, some of the allowances are not paid. It's not correct. So once you don't have the financial independence, you make the institution subservient to the executive and the legislature. How often do you see the executive going to beg anybody for money? The largest of state funds are with the executive. So we must financially insulate the judiciary from interference from the other arms of government. he speaks about appointments, for example. He
Right.
calls for improvement in the appointment system. In other countries, for example, when it comes to the Supreme Court, we have a bit of what I'll call transparency in terms of the fact that the parliament has a role, the executive has a role, the nomination process. He calls for improvement in that system. And I think that we all should welcome such a call, because you have a situation where somebody has served at the High Court for maybe 10, 15 years. He doesn't get a promotion. Why?
Yeah.
You understand? Why? Obviously, it will engender some form of animosity and disgruntlement amongst people. So promotions can sometimes become a tool, okay, for undue interference with the judiciary. We must have a more transparent system for the appointment and promotion of our judges in the judicial system. And he calls for that because he's been there. Okay? So, for example, if you serve 10 years at the High Court, we should be able to legislate that all judges who at 10 years at the High Court should be eligible for promotion. It should come naturally. In other institutions, it comes as a matter of course that when you spend a number of years at a certain point, you get promoted to the next point. It should be so that if I decide to have a career as a judge, I know that my progress as a judge is not dependent on whether or a particular party is in power or whether a particular president decides to nominate me or not. If I decide that I want to be a career judge, for example, I should be able to have continuous promotion based on the merit of my work. If I'm from the private sector and I decide to apply to go to the bench, the process of appointment, like in Kenya, for example, when the Chief Justice position is open, we have they apply, and the panel to vet and approve is an open panel. Even has judges from other countries sitting on the panel. We should open our appointment process up. If you look at
that's the fact that, because these appointments are done in consultation with the Council of State, it's still not enough.
So you see,
for
the Supreme Court,
yes,
for the High Court and the Court of Appeal, it is the Judicial Council. One of his criticisms was that the Judicial Council has a number of appointments from the president, which is the executive. It has a number of appointments from the nominations from the Ghana Bar Association. Then there are other sector interest representatives. We should improve that system, because at the end of the day, how often do you see us advertising for judges to the High Court, Court of Appeal, or even the lower courts? Yes, the adverts are placed, but what is the process? Normally you see that the list has come out, especially for the High Court to the Court of Appeal. We should call for more transparency in this nomination, so that if we have a judicial vetting committee made up, or you want to...
Who makes those appointments to the judicial vetting committee?
That's what I said. We should open it up. That's my point, that the Judicial Council is there. The point is that when there's a vacancy, the nominations must come from the Judicial Council. I'm saying that, where do the nominations come from? That is one question that we always should be asking ourselves. Is it an internal thing? In the time past, the Ghana Bar Association will make recommendations. But I think that if we want to call for greater transparency, we should open it up, so that if anybody wants to aspire to be a judge, for example, you apply. And maybe we have parliament. So like we do for the Supreme Court, let us open it up. Apply and let's have public vetting. So everybody from the district court all the way to the Supreme Court, you have public vetting. Let everybody see who is applying to be a judge, so that if we have questions on your competence, on your morality, on the criteria that has been set by the Constitution, we are clear that the people we are appointing have gone through a transparent process. It is about the transparency of the process that adds to the independence of the judiciary, and the fact that at the end of the day, it is one of the institutions that we must safeguard, so that whenever we have issues, and one of the maxims is that justice must be done and must be seen to be done. It is about the confidence, so that at the end of the day, even if you lose your case, you know that you lost because you had a bad case, and that was it. It is not because there was some manipulation in terms of the person who is sitting on the case, or because of the kind of case that it was, a particular person was brought. All those things must be made more transparent. I think when we do that, it is for the better. So such academic lectures and such academic discussions must be encouraged, so that at the end of the day, we throw light on the judiciary, because it is one of the institutions that we must always safeguard. If we politicize it, we have a problem.
Enoch, please come in.
Thank you, and a very good morning to my co-panelist, Chairman Bernard Mornah and lawyer Nipapo Samoa. and your humble self. Let me start with where Bernard landed with regards to citing some decisions of the Supreme Court that he feels are tainted, i.e. the Justice Abulai versus Attorney General, where the court decided that the first deputy speaker or the second deputy speaker or the deputy speakers of parliament are not speakers of parliament, but they are members with representation, and certainly they ought to have that representative right in terms of decision making in the House of Parliament. We all are aware that constitutionally the Speaker of Parliament is not a member of Parliament. So the Constitution is right in its sense to say that the Speaker cannot vote because the Speaker is not a member of Parliament. But the first deputy Speaker of Parliament and the second deputy Speaker of Parliament are members of Parliament, and as members of Parliament, they have the right to represent their constituents fairly within the House of Parliament when decisions are being made.
Right.
So, where did the Supreme Court err in stating that, in as much as they represent their members, in as much as they preside in the absence of the Speaker, they have an additional responsibility. They can exercise their franchise in decision making in the House of Parliament. So this is living constitutionalism. Our constitution must be seen to be living. Again, Chairman Bernard Mornah cited the case where the Supreme Court decided that citizenship is the birth certificate is not a proof of citizenship. It is rightly so, because around the world, citizenship is determined by law. And even when you take the United Kingdom's birth certificate, it is stated that this is not a proof of citizenship. So all around the world, citizenship is determined by law. And the state in which you are in determines the parameters in which you must satisfy, and the condition which you must satisfy to be accorded a citizen.
But he quotes Article 6.2, in fact 6162. Where does that leave this conversation? Because if the Constitution, which is the highest law of the land, says that every person who, on the coming into force of this Constitution, is a citizen of Ghana, by law, shall continue to be a citizen of Ghana.
You know, interpretation of the Constitution, you cannot just dwell on an aspect, an article of the Constitution. If you want to understand it, senior is here.
But that's,
you must read them as a whole.
If you read this, there's the Citizenship Act.
When I read,
let me finish.
Let me give you an
I will let you speak. Okay. Let me finish. When you read this, there's the Citizenship Act. It actually gives periods, dates within which we can check whether you're a citizen of Ghana, citizen, the one that you can be president. What's the code?
Which one?
That you have to be a citizen by birth.
Yes.
Okay, so there's a time period. If you have before this date, 1957 to this, in all those cases, it didn't say that you need the documentation that you're talking about to be a citizen.
You see, when you are interpreting the Constitution, that's why I said that there are parameters in terms of interpretation. We have the purposive approach, the mischief rule, and all those thereof. In terms of looking at it, why the Constitution stated that all those people born between a certain period of time up to a certain period of time means that before that time there was a particular regime, and we moved from a particular regime up to a next regime, a different regime, from Gold Coast to Ghana.
Okay.
And can you say that before the attainment of independence, you now enact rules to say that all those people who were born outside those periods are not Ghanaians?
At that time, what was their proof of citizenship?
Proof of citizenship. I'm not aware of the proof of citizenship.
Was it not the birth certificate?
This is what the Constitution is saying.
And it
I'm
can all
asking
those
you.
because
But I did
we
not
are
say
not
birth
against the
And so then I'm
I did
asking
not
you
say birth
that
certificate.
I'm asking you that what was the proof of citizenship? What is the proof that this person per Article 6 and even the Citizenship Act
No, they
that
didn't say.
before the coming into the force of the 1992 Constitution, if you were a citizen by law, you are a citizen. You continue to. At that time, before the 1992 Constitution, what was the proof of citizenship?
Birth. But they don't say birth certificate. So these are two different things. Two different things. Because when you go to the NIA to register,
I'm not a
apart
lawyer.
from-
The lawyer will answer.
Apart from, no, we are not going to do interpretation here because it goes beyond the thinking of the imagination of those things. It depends on his subscription, whether he subscribes to the multi-purpose approach or he's a literalist or whatsoever. It depends on your background.
The justice.
Let him finish.
Okay,
Yeah.
So what I wanted to say is that all what Bernard was quoting, this is the court. Article 125 grants the court the power to adjudicate on all matters. They are solely mandated to do same. The court of public opinion can give out their own opinion, but this is statutory, constitutionally, the purview of the court to adjudicate on all matters, and they have adjudicated, and this is the decision of the court, and it must be followed as such. You see, when learned Justice William Atuguba spoke, you can infer from his statement as a former jurist that yes, there is no institution around the world that is beyond reproach. All institutions around the world need reforms, one way or the other, because as and when time changes, then we need to reform according to the tenets of time. Certainly, he mentioned financial independence. Yet, all other arms of government are suffering as a result of financial crisis. Even Parliament, the House mandated to do appropriation, are also suffering as a.
Some ministers' houses are inundated with dollars. That house. Be careful. Not
Please add that.
You see, the director of political affairs of the CPP wants to.
Please don't. No, it's just mischief. Please go ahead, Bernard. Allow him to. We want to understand his point, so allow him.
No, but
So-
he was making.
So in terms of financial independence, the executive is suffering, the legislature is suffering, and the judiciary is suffering. As far as appointments are concerned, whether promotion, and in any institution, in terms of employee motivation, promotions are a form of motivating employees.
Right.
And I subscribe to the tenets that yes, people must be promoted naturally per their performance within their established career paths, so that it will motivate others that if I go through this channel, ultimately I can also aim at becoming the Chief Justice or a Justice of the Supreme Court or a Justice of the Court of Appeal. But certainly, if you come to one way or the other, this is not happening even only in the judiciary, in the foreign service. When the ambassadorial rank is the highest rank within the foreign service, but because there is an avenue for the president to appoint ambassadors to represent the state at certain point in time. Now we mostly bypass the career foreign service officers who have attained that height to be posted as ambassadors and appoint people outside the bracket and does not motivate people well. So if Justice Atuguba is recommending that certainly we must look at ways of promoting people within their ranks naturally, so that by virtue of their competence, so that they will be motivated intrinsically to be able to discharge their duties dispassionately, I am for it. But you see, the words used signified somebody who is pained, scandalous, and a whole lot. You see, he mentions that the case of Mr. James Jachikwesin ought not to have gone to the Supreme Court because the High Court has adjudicated on this matter. I have followed Justice Atuguba's ruling, and Justice William Atuguba subscribes to the modern purposive approach to statutory interpretation. And it was Justice Atuguba who ruled, and Leonard, I'll just refer your mind to that ruling in the case of the Mekankan principle, which stated that when
This thing you are saying, our viewers don't know.
No, I'm coming. I'll just
So
break it
try
down.
to relax it
I'll
and
break
make
it down.
it more
I'll break it down. His
relatable.
uncertainty. I'm relating it. His uncertainty. Why I say he's not certain with his path that he's charting, and I could see pain in him, is that based on the Mekankan principle, the court ruled that yes, at some point in time, when statutory provisions or constitutional provisions are clear, it need not to refer the matter to the Supreme Court for interpretation. Judge Atuguba said that whether you say it is clear or not amounts to interpretation, and it must be referred because it is only the Supreme Court that has exclusive original jurisdiction as far as the interpretation of the Constitution and enforcement is concerned. This is the same person who is saying that the issue of justification, which traveled to the Supreme Court, ought not to have traveled to the Supreme Court. So where lies the balance as far as certainty with regards to principles?
But which court has jurisdiction when it comes to parliamentary issues?
Parliamentary issues, it is the High Court, and it ends at the Court of Appeal.
Precisely. So is he wrong?
From the High Court. No, when matters of interpretation comes in,
it goes to the Supreme Court.
When matters of interpretation comes in, when the interlocutory injunction or something was issued by the High Court, and the NDC said that no, they are not obeying it because the High Court has no jurisdiction because this is a constitutional matter. So when constitutional matters are raised, which court has the jurisdiction?
The original jurisdiction is the Supreme Court.
To try or to hear the constitutional matter. It's not the Supreme Court.
Yes.
So if the same person comes back, I am not against the reform that he's proposing. Yes, all other state institutions need a reform one way or the other so that we can make it whole to serve the good people of this country.
But he's not asking for an overturn of that decision. It is his opinion, as we all are entitled to, right? When we read cases and we form our opinions on whether the ruling
a judicial decision
was okay or not.
A public document, and we all can critique a judicial decision.
Precisely.
But as a former jurist, and you say that it is scandalous. It smacks.
Have you not ever read a case and said that it is scandalous before? Have you not?
Oh, for a former judge critiquing.
I'm asking you. You have not.
Choose words for him.
Openly, but you do it inside your room.
You see, he mentions that he was at one point suspended. Was he? Did he supply the public with the document, the letter of suspension?
He said the suspension was in respect of the fact that he wasn't impaneled. He didn't say that he was suspended.
He was to go and sit at home.
So let's be fair.
No, we should also be fair.
No, but we
should also be fair to the institution. You see, when we are preaching fairness, equality is equity. When we are preaching fairness, once administrative suspension or something, if you are not empaneled, it might be as a result of the numbers there, the issues before the court.
As you ask for fairness, be realistic as well.
Yes.
Please be realistic as in your fairness, because how can you say that a senior justice, hold on, a senior justice has not been empaneled? Please hold on. Yes, one at a time.
The decision to empanel justices to sit on a particular matter lies in the ambit of the Chief Justice.
Correct.
So when cases are filed in court, it is the Chief Justice at the Supreme Court. It is the Chief Justice who determines justices who are to sit on those matters. And the justices of the Supreme Court are not just few people to say that. It is only Justice Atuguba who ought to be.
They are 9 to 11. So if for 6 months you don't empanel him, clearly there's a reason why you don't empanel him. So he's not out of place to say that he's being punished because he was set.
You see, when both justices, in the judicial decisions, we have the obiter dictum and the graduate decision. I'm coming. Please.
My guests don't understand. My viewers don't understand.
No, you are not letting my flow. You are not.
They don't understand.
Allow me to land. I'm raising an issue. These are technical issues. I raise it. I break it down.
Okay.
So please,
once you promise to break it down.
if you hold my mouth, you are not being fair to me.
I'm only telling you that.
Hold your mouth?
I'm telling you that you are here to communicate for the ordinary person watching to understand. If you can use another word aside obiter dictum, then do that so that we can all follow the conversation.
I need to raise those two technical issues.
Go ahead.
Explain it myself.
Please go ahead.
But if you do this, you are not being fair to me. You are heckling.
We haven't gotten there yet. Go ahead.
Please, let's be fair. You see, a judge has two stands as far as decisions are concerned, and the ratio is what is before the court. The dictum is his personal opinion, and your personal opinion, like Justice Doche said, creating loot and share was not part of the issues before the court, but it is his own assessment of the issues that he created those scenario just to reprimand all of us to be careful with how we deal with public funds and those kind of things. Where in Justice Atuguba's judgment did he ever raise some of these issues to reprimand or to tell the state that some of these things ought to be looked at? Certainly not. As a senior judge, as a jurist who has sat in the Supreme Court for over 20 years, now There are a whole lot of things going on. Maybe he's paying because he was not afforded the opportunity of being the chief justice of the country.
Why is speculating?
Please allow him.
He speculated.
To accuse you of
no, he also speculated
not being
that he was banished for 6 months without being empaneled. He was speculative because once you are not empaneled, it means that you have been suspended.
It was Tokunu who did that.
Who?
It was Tokunu who suspended her.
Suspended who?
Atuguba.
Tokunu. Was she the chief justice then?
And so, why are you saying that she's paid?
Was he not paid? To say that I was a senior judge. He even quoted Justice Redu and is it Ampere or something?
Yes, he was.
He quoted Justice Redu and Ampere. Yeah. That Justice Redu was the senior most, and at the time, because Ampere was the cousin to the former Chief Justice, whenever the Chief Justice was traveling, he sneaks and hands over to his cousin to take over. And at one point, all these things, you see, all these things, if you have suffered any fate, just be bold and talk about it, that this is what I suffered. And he was not gagged not to speak his mind. You know, he was not gagged. When, during the election petition, when Sir John and Co. was brought before him for contempt, I was in court. And I saw how he handled the matters of contempt properly, using his judicial arms, authoritatively. If something of that nature was going on, I believe that Atuguba was not a coward to have not spoken out as far as those matters meted out to him was concerned. Now, because of politics, look at the way he's ridiculing the same institution that he served over 20 years.
That's bad.
Because of politics.
That's bad.
Look at the way he's ridiculing the same institution.
But you said that the issues that he raised, the reforms, they are well and good, right?
Sam, when you are talking about reforms, I agree with you that every institution needs reforms, because once we establish an institution for over years and we decide that at this point in our lives we must really look at the structure of these things, fine. But there are specials, innuendos, and some of these things that he stated in his remarks clearly smacks of pain. Somebody who is very pained as a result of certain heights that he could not achieve within the institution that he's critiquing. So let us lose sight of the fact that
Chief Justice in this country.
Let us lose sight of the fact, yes, if you act as a Chief Justice, acting, meaning that you are closer to being appointed as Chief Justice, and you were surpassed and a different person was appointed. He rightly stated that in 1769, thereof, lower magistrates and judges were appointed, and the senior ones became third, fourth, and fifth, and those things, meaning that the hierarchy was tilted. Same happened to him. This is what he was trying to infer, that because he was senior judge, he acted as Chief Justice, and so the pain that it is in him. Once he's recommending reforms, he should do so dispassionately.
In one breath, you earlier talked about the fact that when you're working somewhere, you expect to be promoted.
Sure.
That is a reward. So someone has stated clearly that he was an acting Chief Justice of a sort. And there are people who were being brought from under him, and it was like that. You have rightly stated it. And you think that he doesn't have the right to talk about what he thought that was wrong then?
No. If you are recommending reforms, you can even cite yourself as an example.
Is that not what he did?
He didn't.
Okay.
He didn't use himself. That is why I say that he is not bold enough.
Okay.
Because he ought to have used himself. If you are recommending reforms, that yes, I ought to have been promoted to the status of a Chief Justice, but because of reasons A, B, C, I wasn't. Okay. So let us rethink and relook at it, or let us open a national conversation or dialogue, so that we all can make input into it and find ways of reforming this particular structure that is there to serve as an arbiter for all of us. The executive has been tainted, the judiciary, the legislature has been tainted, and now the target is to taint completely and dent the integrity of the judiciary, which we must not accept this agenda to thrive.
Okay. Do you want to quickly, because we have to move on?
I find it difficult to agree with my brother when he says that there's an agenda to taint the judiciary. This is somebody who served in the institution. He has finished his tenure of office. He's been invited to a public lecture. He's asked to give his experience as a former judge and also talk about how to better protect and enhance the growth of the institution. He speaks with experience and he gives you personal examples of things that have happened. Unless you are saying that the examples he gave practically are things that did not happen, including clashes between a Chief Justice that is because by the constitutional provision, the most senior judge is supposed to act when the Chief Justice is not around. And he gave an example of a situation where the Chief Justice then was traveling. He was supposed to hand over to the next senior most. The next senior most was not handed over to, and there was a clash at a conference where the man had to come and tell everybody that, no, I'm the acting Chief Justice, and so I will give a speech. He gave you practical examples. You are not saying that those practical examples are not true, and yet you are critiquing him as if he has an agenda. Where is the agenda? The man has been a member of the institution. He's come out to give his comments and his opinions. He's given examples, he's given recommendations. I think we should look at it within that context and actually take the positives out of it. The last thing about the justification case, I think we should be the issue about the Supreme Court's jurisdiction and the High Court's jurisdiction. This is what he said. He says that, look, the consistent practice of the Supreme Court has been that when a matter borders on interpretation or enforcement of the Constitution, it is the sole prerogative, the exclusive jurisdiction of the Supreme Court. And so whenever a High Court makes the error of assuming that exclusive jurisdiction and it is brought to the attention of the Supreme Court, the Supreme Court has consistently set aside the proceedings in the High Court, assumed jurisdiction in the matter, and gone ahead to do the interpretation in respect of that part. And the position has been consistent. The examples are many from this man, the former Richard Anani. You can come to Ezenat or Rollins. Anytime the High Court has wrongly assumed jurisdiction in an interpretation or enforcement issue, the Supreme Court has been clear. It doesn't matter what the High Court says. It will assume jurisdiction, set aside what has happened in the High Court, and make a determination in respect of the matter in the Supreme Court. In this particular instance, the facts as they are, and you see, let's always be faithful to the facts. The plaintiff in the Judiciary case went to the High Court and brought a matter that Mr. Judiciary said borders on an interpretation of the Constitution. In the High Court, the plaintiff opposed when Judiciary's lawyers raised the matter of interpretation. When the matter went to the Court of Appeal, again, the lawyers of Judiciary raised the issue of interpretation. The lawyers, the plaintiff in the matter said there's no issue of interpretation. Then you go around after the decision of the High Court to the Supreme Court and raise the issue of interpretation. And you say that nobody should criticize that because the High Court had assumed jurisdiction on the matter, made a determination on the matter. What was the Supreme Court going to determine again? The Supreme Court again went into the matter and dealt with this as an interpretative matter and made pronouncements on it. And Justice Atuguba is saying, if a High Court has made a determination of a matter and it bordered on interpretation, and you, the Supreme Court, wanted to assume jurisdiction on the matter, then set aside the proceedings in the High Court. But when the High Court has determined the matter, and you come back again as the Supreme Court to literally go over the same matter, it is inconsistent. And he described this, that is his opinion. Again, he describes this as scandalous. That is his opinion. If anything is wrong with what he said, you have a right to set up a public forum as well, do a lecture, and also counter what he said. That is the beauty of an academic debate. We are in this country when, after the election petition involving our current president as plaintiff, the MPP organized the forum at the National Theatre and critiqued the decision. Did we say there was anything wrong with that? That is part and parcel of building a democracy. So let's look at the message of the person and not the messenger. I think when we do that, we all learn. We all build a society. But when we impute motives to somebody who has been in, you see, the moral authority that Mr. Atuguba brings is one that you find difficult to attack. So clearly, instead of attacking the message, let's look at ways and means of looking at see whether we can attack the messenger. You and I know that his position on issues and his moral authority on issues becomes difficult for you to subject him and paint him in political colors.
Okay.
It's difficult. Let's attack the message, not the messenger.
All right.
Well, I think we should move on.
You want to have a rebuttal to that?
No, we should
Okay.
move on.
No, certainly I don't have anything to say about that. I have made my point clear.
Okay.
That what he said.
You don't have
You
anything.
see, when I told him that my viewers will not understand Obita data, he told me that he will explain it. He will break it down. You see, he didn't break it down.
You don't know Enoch.
Now I know. I didn't know him. Now I know.
You don't know Bernard.
I know him very well.
Then you gave me a
Well,
different-
you know, so that
The word did not do it.
let's move
The
on.
producer that did it, and I wanted to take the producer on, but
But I represent the team. It's an entire team. So you cannot.
actually moved
I
on
did
that
come out.
and I
I
did
mean,
that.
that's
Justice Chum.
Pendream TV.
Are you linking it to the Justice Chum? So that's a
So
different
far,
question.
so
No.
good. Say,
We are moving
online
This one was-
portal, what Ghana.
It was the
Nipa
topic.
share, Nipa follow,
Let's
Nipa
move
comment
on.
here. To my best of knowledge, without any biases, Pendream TV.